Now, joining us live in our Lagos studio is a lawyer, Jefferson Woghiren. We also have joining us via Skype in Edo, Patrick Obahiagbon, Vice Chairman, APC National Campaign Council, who is also joining us tonight. Let me begin with you, Honorable Obahiagbon. Sometime in December, some of these lawmakers-elect at that time, their seats were declared vacant by the House. On what basis and on what authority is this new move taken?
Two issues arise when you talk about declaring seats of members vacant. The first question that arises is that can you declare vacant seats of members that were not inaugurated? That becomes something of a legal and parliamentary abracadabra, which all compos mentis homo sapiens poo-pooed at that time. The second issue that arises is to even assume that we have a legal, validly constituted House of Assembly ab initio. You know, for you to be able to even say you want to purportedly declare seats vacant, it means you yourself, you are dressed, you are legally habilimented. Now let's talk to the law, irrespective of namby-pamby political sentiments. I want to address the law, and I call to question the clear provisions of Section 91 of the 1999 Constitution. Section 91 of the 1999 Constitution amended says, subject to the provisions of this Constitution, a House of Assembly of a state shall consist of 3 or 4 times the number of seats which that state has representatives, divided in a way to reflect, as far as possible, nearly equal population. Now listen to this. It says, provided that the House of Assembly of a state shall consist of not less than 24 and not more than 40 members. And Section 91 of the Constitution is talking about composition of members of the House of Assembly. So when you resort to a vehicle of Mephistophelianism and Gambadoism, and you swear in 9 members, viet amicus, in clear desecration of the pellucid and diaphanous vision of Section 91 of the Constitution. There were
Honorable Obahiagbon, let me jump in very quickly. Let's talk about the process of the inauguration that transpired today. If you can hear me, Honorable, the process of the inauguration that transpired earlier today. We understand that a proclamation must be made by the governor at the hallowed chamber. Thereafter, the lawmakers-elect then vote to appoint a speaker who then also now administers the oath, to the lawmakers-elect. How aligned with law is today's inauguration and the declaration of impeaching the speaker, which were done by the 17 lawmakers?
My brother, you have 7 lawmakers on this side. You have 17 lawmakers on this side. The principle of majority has always been the litmus test of democracy, particularly constitutional democracy. So if 7 members are on this side and they are laying claim to the legal authority of the House of Assembly, and you now have 17 members saying no, we say a capital rejectamenta to that illegal contraption. This is where the majority is, and this is our speaker.
All right, let me just hold you for a minute, Honorable Obahiagbon. Let's bring in the lawyer in the studio, Jefferson Woghiren. You heard the Honorable. His position is that 17 is more than 7. There are 24 seats in the House of Assembly. How do you react to this new development?
Thank you very much. I'm very disappointed to note that my learned colleague seems to be mixing up the issues as regards what is happening. It's like litigating the matter that has been resolved and concluded. The issue of a district House of Assembly was raised and concluded in the Federal High Court, Port Harcourt, on the 12th of December last year, upon the process of proclamation and inauguration that took place on the 17th of June. And some persons refused to make themselves available for that inauguration. And we all know that happened. And in consequence of that decision, some members went to the House, to the Federal High Court in Port Harcourt, and a valid judgment was given. All these issues my learned senior and friend has raised now were all raised in that matter in Port Harcourt, and a judgment was given. And in consequence of that, the House of Assembly on the 14th of December last year declared the seat of this non-attending member, this members elect, vacant. In consequence of that decision, these members elect went to court in the case of Edoro against Okiye. In the case that took place in Port Harcourt, it was the immediately past Deputy Speaker, Yakini Idiye, against the clerk of the National Assembly. So we seem to be mixing up emotions with law here. And we think we need to be very careful so that we do not create a kind of recipe for anarchy. We are creating a recipe for anarchy here. And by the way, what happened today is a veritable invitation to clear anarchy, because in the Supreme Court case of Inokoju against Adeleke, the Supreme Court ruled that the House of Assembly, the matters cannot be decided in the private house on private properties of individuals, where some members went to the River Hotel in Ibadan to go and meet. So what happened today is a clear case of mixing emotions with illegality. It's not a matter of law.
But is this a situation?
There's a substantive court action going on, and the decision has not been reached. Section 66B provides that all persons who have reservations about action should go to court. All these persons, I mean the members elect who refuse to make themselves president and members of the House, they went to court. That decision has not been passed and decided upon.
Mr. Woghiren, what do you consider the legal settlement to this particular challenge?
There is usually the political settlement and a legal settlement. I'm not here to talk about political settlement. I'm a lawyer. We should look at the rule of law. We should not create separate laws for different states of Nigerians. I don't want the impression created that we have majority and those majority have been prevented from going to the House of Assembly. It is not true. Those persons are not members of the House of Assembly. They are members elect, and they remain members elect until decided otherwise by the court. And so whatever they are doing today is ab initio, wrong, and of no consequence whatsoever. Until the matter is resolved in the court that they have applied to, and the decision is reached, nobody should take laws into their hands.
Let me get a final statement from Edo. So he mentioned that there is indeed a political and a legal angle. I want us to explore the security implication of this move. Earlier in the day, we saw that policemen were deployed to the House of Assembly. And you know how volatile Edo is becoming ahead of this election. Are you concerned that the move by these lawmakers might further, bring more security concerns in this regard?
Is that question for Jefferson or is for me?
It is for you, Honorable.
Okay, let me start by saying that I am maniacally bewildered that my friend and brother, Jefferson Woghiren, who says he expressed disappointment in my views, did not express disappointment in a governor of a state who would choose to defy presumption of regularity in law. The state houses of assembly are supposed to sit within a time continuum of 8 o'clock to 4:05 p.m.
I'm afraid that we lost contact with Honorable Obahiagbon there. Okay, Honorable, are you back? I can hear you now. Please go ahead with your contribution.
On the date of that said illegal inauguration, 7 members of the State House of the State House of Assembly were inaugurated at 9:30 p.m. A proclamation was issued surreptitiously. People were forced and hijacked into the State House of Assembly. and Barrister Jefferson Woghiren would not show disappointment at the high priest of that political and legal gabadoism. Now you talk about security. It is the constitutional onus probandi of the Nigerian police to give security to everybody, both minority and majority. And you cannot sweep under the carpet the issue that the political mathematics and political chemistry of this issue just now is that you have 7 members there and you have 17 members here. It is sardonic and lugubrious that the governor of the state desecrated the sanctity of the House of Assembly today and supervised the vandalization of the House of Assembly, supervised the removal of things from the House of Assembly, supervised the cutting away of public properties from the House of Assembly. And my friend and brother is there telling me about disappointment. Disappointment in who? We should be disappointed about the governor of the state who threatens violence, who has showcased violence.
I get your point, Honorable, but we have to wrap it now. Let me just quickly get your final take on this decision, lawyer, because his position is that 17 apparently is greater than 7. Is that also a legal concern that should be talked about at this time? Mr. Woghiren. With
due respect, let me quickly make a small clarification. I have a great respect for my brother, Honorable Obahiagbon. And I apologize to him if you see I've embarrassed him. But unfortunately, he's misleading the public. So I have every right to also correct him that he should not mislead the public so that we don't incite violence. Now, those 17, the issue here is that 14 persons remain as we speak today, members elect, until they go through the process of becoming a member of the House of Assembly as provided by law. They are not members of the House of Assembly. No attempt to circumvent the procedure and processes because they are in breach of the procedures.
All right.
For becoming a member of the House of Assembly. They have been elected, yes. It's like passing jam. But you must go and do your registration in university.
Lawyer Jefferson Woghiren.
These persons are, with due respect, not members of the House of Assembly. So any attempt to circumvent the legal process of making them members of the House of Assembly through the legal process is wrong because these are supposed to be lawmakers.
We have to end it there. Lawyer Jefferson Woghiren, thank you for your take. We must also thank Patrick Obahiagbon, Vice Chairman, APC National Campaign Council, who joined us from Benin in Edo State.
My pleasure.